Here it is, the Sunday before Black Friday. All right, back on the set. Just got to cover up something right now because I don't want Queens District Attorney, District and County Attorney, District Attorney Office in Queens, New York, to realize or think for 1 second that I'm just rested on my. I'm resting where I'm not just doing anything because I'm not trying to. I'm not trying to acknowledge their response because they didn't show up in court on the 9th of November. The judge was there. Judge Zoe was there. He even mentioned that clerk went down to district attorney's office to find out what happened to the reply or what happened to an appearance by somebody from the district attorney office. You know, the strange thing about that is that when I went to my SORA hearing, this is facts. This is record. District attorney said like, oh, you know, something like he got this kind of charge in and you coming out here doing 25 years. You should he should have all kinds of restrictions and stuff like that. Blah, 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 blah. You know, he's a criminal and blah, 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 blah. He was convicted. Blah, 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 blah. He just wanted to just throw all kinds of restrictions on him. So I said, yo, what the fuck is this dude talking about? What? And then my lawyer told me, yo, chill. I got this. Your Honor. Accordingly, I don't have no objections to the request based in law. I understand it's the highest charge a person can have, of course. But among my folder, there's no evidence of anything of any violence or any criminality. I'm missing that from among my records, so I hadn't seen that. So I must object to that. So the judge asked the prosecutor of Queens District Attorney's Office, it's crazy that this got to be brought up. And I mentioned that into my reply papers, so on and so on and so forth. Because the thing about trial judges, the trial judges don't really know the facts of the case. They just know a case is pending against defendants, and the prosecutors is prosecuting based on the evidence they got. So, that being said, moving forward, and to continue and finish the point I'm trying to make is that he asked for all kinds of restrictions. So my attorney objected there, and the judge said, well, objection. And the district judge said, well, I have an adjournment so I can gather the necessary evidence to validate the criminal charge. My lawyer said no objection. The judge said, okay. Objected. Objection. No objection. We set a adjournment and return date for this day here. Fast forward. Return date. A new district attorney or another district attorney now appears, and the judge said, okay, well, this is a continuance from an adjournment on the Aaron Taylor case, and on the Aaron's case, and we got to find out, we want to know, basically, the evidence that's produced so I can determine the restrictions that Mr. Allen has, or Allen has. Defendant Allen has in this case. Accordingly, the district attorney goes back to his folder in his desk and he goes over it and he looks through the pages, which is not many, 1 or 2 or 3. And he said, well, Your Honor, well, accordingly, there's nothing that evidence-wise I can produce to this court today. Or I have to produce. Or there is to produce. But I'm asking based on the nature of the charge. He should have every restriction known to man. So before my attorney actually completed his objection, the judge waived them off. The objection, he waived silent. And said, I made my decision based on his reply. Allen or Taylor don't have no restrictions. The case is ended. Finished. I objected that I had to register. Because if it's obvious that if there's no evidence to produce, to validate the proof of a crime of any kind, then why would I have to even, or why would I have a record of this on my record? Period. I appealed it to the appellate court, which is the next higher court that looks and review lower court's decisions. And the appellate court said, well, accordingly, it's not preserved for appellate review. In other words, the argument that I'm putting in right now that's before this court has to be entertained. The judge have to be given the evidence by the district attorney's office, having a hearing on it. And the judge see it. He ain't blind. He's not incompetent. He's not ignorant. He's not uneducated. You just give him the facts, and he just, okay, cool. Accordingly, that's his jobs to make decisions based on the facts that's given to him to see that he can ascertain and says, yeah, okay, cool. Or no, hell no. What? I don't understand. Where's the, what? You ain't got nothing? That's his job. It ain't got nothing to do with prejudice, like or dislike, culture or non-culture, religion or non-religion. He's a judge of facts, of law, period. It has nothing to do with his feelings. He can say, well, fuck this dude. I don't care nothing about this dude, whatever the case may be, etc., etc. Has nothing to do with that. He is empowered with authority to say yes or no based on law and fact. Yes, that's what he is there. And that's a hell of a lot of responsibility, having that authority and power, because that's what you do. The district attorney didn't show up in court. Haven't had a hearing to produce before the judge. It's easy. The same thing when I went to the SORA hearing, where they have to determine the facts so he can determine what kind of restriction he's going to put on Aaron. And there was nothing. And there was German was granted. My lawyer like, hey, yo, what's going on? But my thing is my lawyer. My lawyer didn't like me. He don't even know me from a hole in the wall. I'm just a client he's dealing with on his quest to become a legal representative of the legal system. Fair, judicious, and injustice. I'm just a stepping stone in his career of fairness and justice. Period. Following the law. Period. So the judge looked at it like, well, you know, don't try to make me look like a stupid ass. Don't do that. And he told my lawyer, he's chill. Well, he didn't say it like that. He just said, no need to object. I made my ruling on this based on their reply. He has no restrictions in the case. That's it. Boom. Case dismissed. I go to the appellate court and say, well, since the judge says da 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 da, blah blah blah, my lawyer tells me, yo, you know something? Pursue that. That's what he told me. Pursue that. That's what he told me. If you don't have a bit of evidence in a case that garnishes a lot of years incarcerated if convicted, that's a travesty of justice. Very travesty. Very wrong. And for any person, and they say they practice law and justice, that's deep. And you overlook the fact that the law is not fulfilled when you saying that this person did something wrong, illegal, against the law, and you holding it down? What conscience? What religion of righteousness, of just, of godliness you claim to hold on to? When you see, whether you like the person or not, when you see, oh, wait a minute, in this case here, it's not that I had to go and find out the forensics, the medical records, the blood exam, the DNA and all that. You ain't had nothing there. How would you like your son or daughter or a member of your loved ones to go through something like that? How would you like? How would you feel someone that you really loved, you cared about, and you know it was wrong? The difference is that I didn't have a family member, nor was I knowledgeable in the education of criminal justice law as I was at that time. I was in completely darkness. And my darkness was exploited. But that said and done, judge told me, said, listen, you got objections. You got not objections. The judge said, you got two choices I'm giving you. He said, you either accept the jury for 1 month or 2 months. That's the option I'm giving you right now, because the district attorney office had not replied yet. Even though I'm thinking to myself, well, shit, they had more than enough time to reply, because it ain't nothing to go down to the record room or the evidence room, snatch up the box bag, whatever you got down there in a sack. Here you go, y'all. That's it. And the judge said, okay, yeah, we ain't got to go through no more than this. All right, forget it. But I ain't going through all that. Okay, that's enough. I'm talking about evidence. I'm not talking about paperwork, statements that is unsupported by some evidence, a fact that they can say, yeah, okay, I see. Okay. There's no injury. There's no victimization. No one got hurt. No injuries, no weapons, no even assault, no even threat. There was name alleged that had witnessed me approaching them, her and him. There's no name. There's a referral to persons that was there during when incident happened of criminality. No name nor any statements by alleged somebody, not no name. Alleged somebody was there that day he approached. Well, if he approached that in that day, and that was your people that cared for you, that was there for you, of course they would say, yeah, I remember that dude he had, blah, 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 blah. If that didn't happen, then it didn't happen. If it happened, and that loved one was there, you would say, oh yeah, I remember that day, yeah, the dude came, but blah. Okay, well, that's something different. And my name is such and such and such and such. And this is what he said. Yeah, because the detective that wrote up this false police complaint, judicial misconduct, yeah, she done that. Yeah, she just like, okay, prosecutors do. I want to make a name for myself. Fuck that. He don't know. I can tell he don't know nothing about this criminal justice system, cause she can tell. So I'm gonna take advantage of this. And the person she dealt with as the prosecutor, she just had some kind of influence over here, one way or whatever, however it was that she did have influence over him, that he went for it. He didn't give a fuck. And he know that there was no crime, because the paper document I got that she gave him to use to prosecute me, it says no medical records, no medical treatment sought, no visitation with no medical, a doctor, no anything like that. No kid, nothing. No weapons, no assaults, no threats. It's based on just the police report. So that she's referring back to herself. I wrote this up, and it's based on what I say. That's what she's saying. But that's not how the law says it's supposed to be. The law says you cannot convict a person under the penal law of 130 without having corroborating evidence. Something has to be presented to substantiate, to support that allegation. It ain't that simple. It ain't that easy. You're taking years of personal life. We're gonna make sure this is right. That's the bottom line. But anyway, what I'm gonna do is conclude right here to get this off and over with, so I can finish going over what I'm going through and going over what I need to go over, so I can get understanding, better understood as I move forward, and understand more is what I was taught a long time ago. Listen, American law is no joke. It's real. If you take it for granted and you overlook it or undermine it, it could be to your detriment. So God bless and become aware.